Well, the Orange Bowl boys are very happy and excited. This is going to be fun. The biggest story in college football over the last week or so has been what's been going on with Xavier Lucas. So why not go to the man that started this whole thing? Darren Heitner is the adjunct professor of NIL at the University of Miami School of Law. We won't mention the fact that he went to Florida because everyone's got blemishes on their mark. Darren, how are you, man?
I'm doing very well. Thanks for having me.
It's the Heitner Show. It's the Heitner Show.
For every show.
We just
what do
did
you
it.
mean? Come on.
We just did it.
You just did it, and you can't stop him now.
Thanks for jumping on with the boys, man. We appreciate you.
No, I appreciate it. Rusty, thanks so much for pushing me to come on and for getting me keeping me awake. Because
That's the thing. The biggest problem wasn't the day; it was the time of day.
I know.
Getting this guy to stay up past
I'm
the
an old man.
sundown is kind of tough these days. So look, we appreciate you coming on. Obviously, I think, where do we start? I mean, I'm just kind of really confused, surprised, not confused. I'm surprised by how this entire thing has gone down, from the fact that it was known that he had requested. It was known that they weren't putting him in. It was known this. It was known that. And then it just kind of went sideways. And then they backed it up with some verbiage a couple days ago that I was shocked by. Where's this going? What happened? Can you give us some backstory?
Yeah, surprised, shocked, confused. I think those are all proper adjectives to use in this situation. I try to keep abreast of everything that's going on in the world of NIL. And admittedly, I think it was in the middle of December, perhaps December 17th to be specific, because for some reason that date comes to mind. But I was sent the tweet that Xavier Lucas had published by multiple people. And to be completely honest, I had never heard Xavier Lucas's name before. I'm not big into recruiting. And I was sent this tweet and the prior tweet, which was the original one where he says, thank you to Wisconsin, but I'm putting my name in the transfer portal. And then the subsequent one where he says, I don't really understand what's going on. They're not putting me in the portal, to sum it up. And I remember, after speaking with a few people, I'm like, you know what, I've got to comment on this because I just can't keep my mouth shut. So I did one of those quote retweets and basically said, what the hell's going on here? Does Wisconsin's legal counsel have an appreciation for what they're doing? And this is before I really dug into the NCAA bylaws with respect to the transfer portal, and specifically the rule with respect to 2 business days. And so at the time, I connected briefly with Xavier and his family, but was not retained. But I realized that he was given the same MOU at Wisconsin that I had seen in negotiating for other players at other Big Ten schools. And I wondered to myself, if this is Wisconsin's basis that he signed this document, how could they possibly decide that they're going to rely on that document to violate an NCAA bylaw? A week or two went by and I hadn't heard anything. I understand that he and the family retained some other lawyer, got nowhere with it. And then they reached out to me and said, Darren, we want you. Can you help us? And I said, as I typically do with clients, can't guarantee results, but I can guarantee you're going to get my best efforts. And I just went to work immediately. I continuously tried to reach out to Wisconsin, got nowhere until the very end. I continuously reached out to the NCAA, actually made inroads there. Unfortunately, was told by the NCAA that they can't force Wisconsin's hand to put him into the portal, even though the bylaw states that they have an obligation. It uses the word shall, but that the only thing that they can do is take action afterwards and punish Wisconsin for not following the rules. And at the same time, was busy drafting a complaint. I said, we're under the gun because, again, the family waited to hire me. So with the deadline for admissions at many schools coming up, I needed to do something, not knowing whether Wisconsin was going to get back to me, having the realization the NCAA was going to do nothing about it. So I drafted a complaint. I was in the process of drafting a motion for preliminary injunction and temporary restraining order, which would hopefully cause a judge to say, you're allowed to enroll at another university while we work all this out. When I realized there's a workaround. and that's just unenrolling from Wisconsin and then applying for admission at another school. And as we sit here and talk about it right now, it feels like it's common sense, right? Like, how could no one have thought about this before? Yet I'm not aware of this ever happening before. So, and what was so interesting, and I'll say cool, was that after we made this decision, knowing, by the way, that this was allowable because I was told so much from the NCAA, the NCAA actually came out with a statement that was published by Ross Dellinger, essentially saying there's nothing in the rule book that says an athlete can't do this. So we felt and feel really confident with our decision making. Rusty, I think to your comment, it was silent for a really long time, or a really long time in the scope of the 10 or so days that I was working on it, I'll say. And then in comes at like 8 p.m. Saturday night a statement from Wisconsin, followed by a statement from the Big Ten. And I didn't expect it. Not a single person I've talked to since then expected it. And it's still surprising to me to this day. And it'll be interesting to see if anything follows from that. My speculation is that this is the end and that they won't escalate it. But at the same time, I thought early on Wisconsin was just going to fold and say, we understand the rule is the rule. We'll put them in the portal. It's not worth the collateral damage of holding our position. I thought Wisconsin was not going to issue a statement. I mean, admitting that they violated the bylaw. So I don't think that they'll file a lawsuit, which means they probably will.
All right, so wait, quick. Let me just before we get past this, the loophole, the common sense move of just disenrolling and re-enrolling. Isn't that how it was done before the portal? And they would just attach a year sit out to it. So that was the process before. Right? There wasn't a portal, correct? Yeah, it was. So it's the same. It's the same process, but now they're not willing to attach you have to sit out a year because they know they can't.
So now you're right to an extent, right? So what we determined was that there's actually no bylaw that prevents an athlete from doing this. And we received assurance from the NCAA that there would be no punishment for Xavier to unenroll and then apply for admission elsewhere. There is a bylaw that states that an academic institution or an athletic program cannot contact a player who unenrolls for an academic season or an academic year. So our workaround was, let's not communicate directly with the athletic program. Let's just apply for admission where we know we want to go. And once you're admitted, of course, you have to be able to communicate with the school. So that was our workaround. And again, we feel really comfortable in speaking with the NCAA that that's not an issue.
So the Big Ten Media Day, are you invited?
Oh, yeah, front row.
See, and this is why I love Twitter.
A name tag on too,
formerly known as Twitter, because early on, and I know you're getting just monumental heaps, especially from Wisconsin fans and connoisseurs.
Yeah. I don't block anyone though. I don't block anyone.
Well, you're a stronger man than I have a weird blocking theory. Like, I'll mute you, and then when I unmute to see what you're saying and you're still doing it, then I'll block you because you got like a 3-strike rule with me. But a couple people have violated that throughout time. But I love it because somebody, and we're very familiar with you and your reputation down here. But somebody said, "Oh, look, it's another Twitter lawyer."
Yeah. I seen that.
And I immediately I subtweet. I'm like, you might want to look this one up.
Yeah.
No, I get it though. I get that there is still like a stigma of speaking your mind. And like I saw someone earlier say when I went on the Feinbaum show, "Oh, thank you for revealing your entire legal case." It's like, well, I'm not concerned that I'm showing our cards. It's like, what do we have to hide? I don't want Wisconsin to file a lawsuit against my client. Like, there's no one benefits from that. And that actually goes back to a comment I also made earlier, which is because, we spent the time, I spent the time drafting 28 pages in a complaint and many more pages in an injunction motion, and I'll never use it. And I would have liked to file it, but it wasn't in my client's best interest. Just like it's not in my client's best interest for Wisconsin to file a lawsuit. There's nothing I can do about that if that's the course they decide to go on, and we'll be ready, willing, and able to defend and file a countersuit. But like, I'm not fearful that I'm showing my cards on Twitter about all the applicable defenses and strong defenses that we have. I hope that it actually persuades Wisconsin and the Big Ten to back off, because that's what they should do for many reasons, not only legal reasons, but reputational ones. Like this is only going to get worse for Wisconsin the longer this stays in the media.
Yeah, and I think I follow-up question to that. As you mentioned, it's a tandem here, right? It's Wisconsin and the Big Ten. It's Big Ten and Wisconsin. Like it's their boilerplate template as far as that MOU, right? So if this goes down the road of them filing suit against Lucas personally, at what point, if at all, is Miami and the ACC then involved?
I don't think Miami and the ACC are involved directly or even indirectly if the lawsuit is only filed against Xavier. One, I also don't think the Big Ten would have standing to file a lawsuit against Xavier. The privity of contract is with Wisconsin if you in fact deem the memorandum of understanding to be valid and binding and enforceable. And for many reasons that I've laid out already, I don't believe that. The other thing to point out is if they were to sue, I can't fathom a judge deciding to provide them injunctive relief to prevent Xavier from playing for another university, here specifically the University of Miami. So then we get into monetary damages. But I also question that. I've been an open book on this. Xavier wasn't paid anything from the University of Wisconsin. And in fact, it's quite clear that he couldn't have been, because this document that he signed was all premised on the final approval of a settlement in an antitrust case known as House v. NCAA. And the final hearing on that settlement won't occur until April 7th of this year anyway. So what are the monetary damages for Wisconsin in all this? Zero. So it really doesn't make a lot of sense. The only reason why Wisconsin would probably file a lawsuit is based on pressure from the Big Ten, because if you think about it, why would the Big Ten stick its neck out and even issue a statement that same day, which obviously was orchestrated to be sent out within minutes of Wisconsin's statement? Because as you said, Rusty, this is a contract that wasn't developed by Wisconsin. It was developed by the Big Ten. So now they're fearful, especially the more that I talk, I suppose, that this contract may not be valid and binding, not only in this situation, but in other situations that it's been used. And oh, by the way, not every Big Ten school has felt comfortable using this contract, because I've done some deals for players this cycle at other Big Ten schools that the deals were strictly with the collective and not through the schools. Not every school is comfortable doing this yet, but many are. And I think that's what the big fear is. But yeah, as far as a case against Xavier, yeah, I don't think the ACC or Miami gets involved. Now, obviously, if Wisconsin and or the Big Ten brought a claim against Miami for what they called tampering, then yeah, Miami and maybe the ACC gets involved as well.
Sure, and that was mentioned, but let's be honest, right? I'm sure there's some trails where Wisconsin was doing the same. Like I was that was the most surprising thing I saw them put on paper, because you're telling me that somebody can't dig up some information on you guys easily.
Yeah, I mean, I've had multiple agents reach out to me since the statement was issued, saying, I don't want to get my clients in trouble. I don't want to get the specific coaches in trouble, but holy moly, like pot
but for the
kettle
good of the
black.
kids,
like yeah,
let's be honest here.
Like yeah, if we're using this word tampering, which I don't really feel all that much comfortable utilizing, and I'm a bit surprised even that Wisconsin used that word, because it implies an employer-employee relationship, which they've resisted over and over again. But if we're going down that path, yeah, I mean, as I said in my quote retweet, which was pretty lengthy, I'm digging up my own evidence if necessary to show that this is what they've done many times over. And again, I've spoken to quite a few people who, have been directly involved in those communications, and I suppose can be subpoenaed if necessary.
So did you break the portal? Like, is the portal going to exist in the spring window, or is it done now?
I think the answer at least is yes for now. I think if I would have filed the lawsuit, I could have broken the portal because the lawsuit was going to be brought on antitrust grounds, obviously making specific reference to this issue where my client was being held hostage simply because he wanted to play close to home with an ill father. And oh, by the way, like all these Wisconsin fans who are questioning whether that's true, shame on them. It is true. And we haven't, revealed exactly what the health issue is, and I don't want to, but um, Xavier really wanted to be close to home because of his father. So that was going to be out there in the open in this complaint that was based on antitrust. It was going to be against the NCAA and Wisconsin, and the relief that we were requesting partially was to blow up the transfer portal and to allow people to transfer at any point in time during the season and speak with collectives and speak with universities and so on and so forth. So that didn't happen because we found a solution in this.
I mean, it's bad
instance.
Enough already. We don't need a worse.
No, I know. And that wasn't my goal. My goal is not to create the most chaotic system and allow everybody who's been screaming wild, wild west for the past 3 years to have legitimacy to that claim. My goal was to free Xavier Lucas, which we did. And so I've got the template, utilizing a word I guess that the Big Ten uses, but I've got a template in case we need to use it in the future. It's all teed up, but no, I think the transfer portal will still exist, and it plays an important role, as I mentioned before. If a player goes to the transfer portal, there's no prohibition on another school communicating with the players. So you don't kind of have to utilize this workaround where you're not communicating directly with the school, in our case, and you just apply for admission. I mean, at least here Xavier knew where he wanted to go, but that's not always the case when players enter the transfer portal.
So it's nature, right? People display or animals display puffery because usually in nature that means they don't have the upper hand. So I felt like when the Big Ten, that was their plumage. That was, we have to save face. But this is where I'm feeling right now. They just have to do that to save face. I really think in my heart of hearts, and I want to see where you feel here, that, yeah, that's probably going to be the last of it.
Again, if we consider Wisconsin and the Big Ten to be rational actors utilizing logic, as most people and entities do in the Western world, then yes. But as I mentioned before, like this never becomes a national story if right after Xavier Lucas sends off his tweet, Wisconsin just puts him in the portal. This doesn't become a national story if once I'm engaged and I reach out to Wisconsin and communicate with the NCAA and get assurance, by the way, from the NCAA that even though the portal had closed because Xavier had tried to put his name in, if Wisconsin decided even after the portal closed to put his name in, that would have been effective. So he still would have been in the portal. This never becomes a national headline. They resisted, and it became a national headline. And again, a logical person, a logical entity in my mind would have never let it go that far. Swept it under the rug, caused really probably no long-lasting reputational harm. A rational, logical entity the size of Wisconsin and the Big Ten wouldn't have taken the bait and put out a statement. So, going back to what I said before, I don't know. I mean, I in my heart of hearts, I would think they don't escalate this, but they've gone the other way. It's sort of something I've said about the NCAA for as long as I've been practicing, for 15 years. It's like, I always feel like whatever you think the NCAA is going to do, if that's zigging, then you should zag, right? Like they're going to do the opposite. So maybe that's,
But
well, as I said, we'll be prepared if they go that route.
What do any of them gain by this? That's what I don't understand. Like, this is not a thing where they were out money and they're like, no. Like, we paid you, you signed a contract, you're obligated, you either pay us back or there's a strict stipulation in there that you can't leave now that you signed that for. Like, what do they gain? Like, this is nothing but poor publicity for them.
That's what I think. Maybe at this point they feel like they're so pod committed that they have to make a statement because they fear that every other athlete who has signed one of these at Wisconsin can easily get out of it. And at the larger scale, at the Big Ten level, they're feeling that it's not just Wisconsin, but any athlete who has signed one of these at another school, like a Michigan State, a Nebraska, any of these other schools could do the same. That's obviously not the overall intention here. This is a very specific set of facts that led a player to desire to leave, and it's a familial issue. And certainly, if let's say he had been paid, that may change the whole way in which we viewed the scenario. He hadn't been paid yet, so I don't know that I would have those concerns, but I think that's probably what they're thinking. Now, I also I have to laugh a little bit when I actually look at what the fan base is saying, which is like, oh, we at Wisconsin should take on this burden now to fix college sports. And the way to fix college sports is to sue Miami and sue Xavier Lucas. Now, obviously, that's not what Wisconsin and the Big Ten are thinking. I think, if anything, it's what I said before.
So
I have more. You said you had something, Ro.
No, it's quick. I mean, just hearing it laid out and just seeing what Darren was able to accomplish. Because remember, it's Free Willy. Just now, it's Free Lucas. He's just jumping over a jetty into the South Beach, ocean right here. So I'm going to say, Darren, you're the 5-star attorney. What the other guy? Like, what are we ranking him, boys? Because well done.
Look, I think that I was thinking about that.
All American, 5-star, 5-star.
Yeah. I think that they were just trying to slow play and hopefully they got nothing out of it and everything passed and blah, blah, blah. And then Darren got involved. Well, I think that's what happened with the other guy.
MOU, they feel the MOU is binding, right? Wisconsin, that's what they believe.
Yeah. Look, I've seen
wouldn't there be arbitration tied into that? So that's how something like this would get resolved?
There is a dispute resolution process nestled in the 7-8 pages of the MOU. It does require some efforts by the parties to try to resolve it peacefully before it gets escalated. I don't recall offhand whether it's arbitration ultimately if it does escalate to litigation to a formal dispute. I actually think that there is not an arbitration clause. I think it would be litigation, and that if it's specifically like a breach of contract claim that falls within the scope of the MOU, I think the parties agreed that jurisdiction would be in Wisconsin, which obviously is not favorable. But for the reasons I talked about before, even if, let's say, we didn't have a strong case on the merits, from a damages perspective, I don't know what the damages would be. But yeah, so, again, I've looked into the long game if in fact they go down this road, and we feel quite comfortable. Now, if they were to file an action against Miami, that's different because that wouldn't be based on any sort of contractual claim. And so it's hard to speculate as to what their causes of action would be. Although if I had to, I guess it would be like a tortious interference with contract. And, whether that be in state court or federal court.
I mean, Darren, with all due respect, I mean, for damages, it's -3 degrees in Madison right now. I mean, that there'd be damages. Like that's, bro.
Yeah.
Look, we know that you are, and we won't keep you forever. I know we get the game on here.
No, okay.
Notre Dame is up 7-0. Who do you got? Who do you want to win this game? First of all,
I don't have a dog in the fight. I was looking at the line before the game, and I forgot. Yeah, it was like 8.5, I think, and I forgot that with the Hard Rock app, you can't do player props on college games. So I kind of wanted to do an Ohio State money line with what Smith is the wide receiver getting a touchdown, but
there you go. Yeah,
I couldn't do it, so I'm like, because Hard Rock tries to con you into those boosts.
Boosts never hit.
Boosts.
Yeah, the profit boost. So we
profit boost for them.
Yeah, we'll get you out of here pretty soon. So obviously you're just very involved in NIL, right? You're very for NIL, which I believe that all of us are for NIL. I think that it's very important that these players are able to get paid. You also referred to it as the wild, wild west, which for the past 3 years, it has been unabated, right? It's just been a calamity of whatever, whoever, wherever, didn't make any difference. Do you have you thought about, would you make any recommendations on how to get this thing tidied up to where it's much more useful, regulated,
organized,
if you will,
yeah.
organized? Like, how do we make this not such a disaster?
It's easy. I mean, it's easy conceptually, maybe a bit harder in practice. And it's not necessarily a net positive for athletes as a whole. It is, in my mind, for schools, presidents, chancellors, conferences, and the NCAA at large. And it is to finally recognize football players and men's basketball players as employees of the universities and or the conferences, and to bargain with them. The reason why the NCAA and the conferences and perhaps the schools keep getting sued over and over, and why they keep losing, and why the bylaws keep, why the goalposts keep shifting with respect to the bylaws, and why we can find a creative solution for Xavier Lucas to leave Wisconsin and apply for admission at Miami, is because without recognizing the athletes as employees and without bargaining with them and instituting rules in a collusive manner on them without their input, it runs afoul of antitrust law. And all you have to do is look at the Supreme Court decision in Alston v. NCAA, which was not that long ago. Not only the majority opinion, but also Justice Kavanaugh's concurring opinion. And it's quite clear on a 9-0 decision what the position of the highest court in the land is. And that's Republican-appointed judges and Democrat-appointed judges, all deciding the same way. And then we've seen many recent decisions, including the Tennessee-Virginia case against the NCAA, which talks about now allowing collectives to communicate with players. In the Ohio case against the NCAA, which opened up the transfer portal from what you talked about before, where you had to sit out a year, to now being able to transfer in 2 separate windows. With Diego Pavia, who was able to get an extra year to play, rendering that JUCO rule obsolete, at least for the time being. At some point in time, you would think that the schools, the NCAA, the conferences wake up and say, we're tired of losing. We need to finally recognize these people as employees and bargain with them. And as I said before, it's not necessarily a positive for all the players, because if you institute a cap that's actually collectively bargained, you can't sue about that afterwards. You can't say that's an improperly placed upon cap. Like, that is what your limit is. That's why it works in the NFL. That's why, it works to an extent in the NBA. And so I think that is the solution, but there's just been so much resistance to it. And as long as there's resistance, I mean, if you look even at this Big Ten template, they go to extremes within that document to make the athlete acknowledge that this is not an employment agreement. So I don't see that changing anytime soon. It probably changes through litigation, and there is a pending case on that in federal court to classify football players as employees. But until that happens, I think you're going to be left with, the quote unquote chaos and wild, wild west that you referred to.
And when you say employees, that means union.
It means
that's where my head went.
Yeah,
and
it can be.
Who's the player union rep? Who are we voting?
Well, yeah, right. And there are different groups that are actively trying to grow right now and are vying for that role to be the bargaining unit for the players. One of which is a group called athletes.org, run by a friend of mine, Jim Cavell, who started a company called Influencer that was bought by Teamworks. He's done very well for himself. They just hosted an event in Atlanta surrounding the national championship game. And, they had 50 players there at a conference. And, but 50 players is obviously not nearly enough. And they have a much larger membership. But even 2,000, 3,000 players is not enough. So I think that's the biggest challenge. You have a very transient workforce that's in college for, let's say, 4 or 5 years. And there's just so many of them. Even if we're limiting it to football players at the power conferences and men's basketball players at the power conferences, it's a big job to organize them.
It's fascinating. I would love to be on that, just see that initial contract. What would be bargained in, bargained for? It's amazing. What would they be willing to give up
to put that together?
Yeah.
Well, but look, in the NFL, it's a uniform player contract. It's a UPC, right? I mean, in every pro sport, there's very little negotiating of the basic terms that the agent's doing. The agent's basically negotiating compensation, and the rest is boilerplate. When I've done probably close to 40 contracts this cycle for high school players and transfer players at obviously tons of different universities. And I can't tell you the difference revenue share contract to revenue share contract and collective contract to collective contract. And it's a cluster, you know what? So there would be a big benefit, I think, overall for the whole system if you had a uniform contract. The problem right now is you can't force that on a player. And oh, by the way, it's not something I've really discussed publicly thus far, but let's say the Big Ten and or Wisconsin tries to impose their will and escalate this. Well, now we have to wonder, without collective bargaining, without a labor system, under antitrust law, is there an issue with a conference telling every school, use this template, and the school's basically giving the contract to the players and saying, take it or leave it?
Yeah.
Look at there.
This whole thing. Darren, any
they don't want to
chance?
Escalate this.
You don't want to.
Here's the thing.
That makes you want to think about it a little
But is
bit.
there any chance that a rogue chaos lawyer agent wants to say, you know what, I'm gonna light the dynamite and takes your blueprint now and files it for some other player down the line and blows up the portal?
Yes, it's likely.
Oh, it is likely. I was going to say, is it? You think? No, 100%.
Yeah.
All right.
Oh my God.
Oh, this is insane.
I know.
Well, thank you so much.
We can talk about this for hours. This is nuts.
I know.
This is nuts.
Well, I'm teaching my course at Law this week, so
does it start
I'm
tomorrow?
down for a day. There we go.
How according to the Wisconsin fans, how can anyone trust me? I mean, I teach at Law, so obviously.
Now, Law, any concern that you're associated with this and people may think you were hired by the university?
No.
Okay,
A good friend of mine, Greg Levy, who's an amazing person. I don't know if you know him. He's an assistant dean at Law, who is responsible for bringing me as a professor. Actually saw that I was going to be on Fine Bob today. He goes, "Give us a plug." Greg, don't get me in trouble for saying that.
I'm pretty sure I told you to do the same thing. I don't think that
I think you
happened
did.
either.
I think you did.
Yeah. I'm like, boy, you can easily name drop us on there.
All right. No, I'm not worried.
Well, Darren, listen, man, thank you very much. We appreciate it. Know you're crazy busy. Get some sleep. And thank you very much for getting getting Xavier freed, and looking forward to the impending doom of the portal.
Until the next one. Take care, guys.
Take care, man.
Thanks, D. See you, bro.
Yep.
As always, go Canes!
Go! Bange.